Welcome to Resolutions, the official podcast of the American Bar Association section of dispute resolution. Every episode is a journey into the heart of conflict resolution, guided by our diverse community of experts. We're here to explore innovative strategies, share wisdom from the field, and inspire excellence in resolving disputes. Whether you're a dispute resolution professional, a curious learner, or someone passionate about fostering understanding and peace, you're in the right place. Let's dive into today's conversation and discover how we can transform conflict into opportunity together.
Welcome, Paula.
Thanks for having me, Aaron. I've been looking forward to our conversation today.
Well, they sent me a complimentary copy of the book. I had a chance to look through it. It's fascinating. What motivated you to write this book?
Well, at my core, I'm a helper. I started in litigation over 25 years ago, really wanting to help people. But I quickly realized that the adversarial system was making things harder for families. So when I transitioned into mediation, I saw a new problem. We are taught how to resolve conflict, but we're rarely taught how to actually manage the case. So I wrote this book to share the exact operational framework that I've developed because I want to help everyone involved in these disputes. So this book is not just for attorney mediators. It's for the financial professionals, the coaches, and the therapists supporting the family as well. When all the professionals share a clear, neutral roadmap, the whole team can guide the clients through these complex cases with much greater clarity and far less wasted time and resources, which frankly is very important to our clients. And just to explain a little about what neutral case management is, I think of it as really providing the red "you are here" dot that we all look for on town and airport maps. Nobody likes to feel lost, right? If we can help our clients to see where they've been, where they're going, who's doing what, and what's happening next, they won't feel lost and they'll know that someone is steering the ship. That's where the title came from for the book. Because especially in family law cases, clients who feel lost are not in the best frame of mind to make reasoned decisions that we want them to make to reach their own goals. A case, I think, that is adrift, where nobody knows who's supposed to be doing what, is a case that stalls, takes more time and energy that might otherwise not be needed if there was a team leader gently nudging things forward at every turn. This is why I consider case management skills to be just as important as facilitation skills when it comes to complex mediations with so many moving pieces.
Again, that's a big difference between mediating, let's say, a dispute between two business parties and actually working with individuals. In family law context, sometimes businesses might have massive teams of attorneys and internal case managers set up in their legal departments and all that kind of stuff, but you don't necessarily have the same thing when it's two people going through a divorce.
That's right.
Traditionally, most mediators see themselves as facilitators of settlement discussions between parties, but you see them more as team captains. What do you mean by team captain? And does the neutral run the risk of no longer appearing neutral if they become too involved with the outside players in the process?
Well, when I say team captain, I mean that the mediator is relying on the same exact skill set as, say, a corporate project leader. So just as a project manager in the corporate world steers a complex initiative by coordinating between different departments and the case managing, and also, just like you just said, also in these other complex cases, it's coordinating between all these departments. So just like that, the case managing mediator steps in to guide the clients, the lawyers, and the experts from the outset to the completion of the case. So it's about drawing on our legal knowledge, our communication skills, and our organizational expertise to serve as the central information nexus. Because the mediator isn't making assumptions or taking sides. Instead, they're managing these details from a neutral perspective and ensuring neither side is disadvantaged. So from my perspective, a great mediator really drives the process while the clients drive the outcome, right? They are the decision makers. This concept of a team leader, as I said, really does apply far beyond family law to any complex civil dispute. Because when we interact with outside professionals, we're really stepping into the role of being this advocate for the process itself by choreographing the interplay between all these moving parts. This protects our clients in all these different areas from unnecessary delays, miscommunications, and overlapping fees, which of course no client wants to have overlapping fees. But as mediators, if we're firmly shepherding the process, just like a strong project manager does, we're actually reinforcing our neutrality. And everyone involved can actually really clearly see that our agenda is to keep the ship steering efficiently toward a structured resolution, of course, without ever dictating what the final resolution is going to be. And, Aaron, when I discuss case management skills, I like to remind mediators that we're not ignoring our mediation training and becoming, micromanaging dictators. Instead, we are building on our mediation skills. We are still mindfully mediating, and we are bringing more clarity and efficiency into the mediation process as neutrals.
Now, mediation is used across all different types of cases, but you point out in your book that the traditional civil mediation structure doesn't usually work best for family law cases. Can you elaborate on that?
Yeah. In my experience and, my prior career before family law, I was a civil litigator and was involved in a lot of civil mediations as well. Traditional civil mediations really typically rely on this one and done kind of settlement conference style structure. With high pressure, clock ticking strategy where parties are sequestered, for an all day and often all night intensive session. Now, civil mediators may point out that cases like wrongful death or catastrophic injury cases are also intensely emotional, like family law cases, which is absolutely true. But there is a critical difference in the aftermath. In an emotional civil case, the resolution is usually a one-time financial exchange, right? Once the settlement agreement is signed, the parties never have to see each other again. That high-pressure structure works because the only goal really is complete finality. Family law is so different because we're helping people dissolve a life together. We aren't just closing the book on a past event. We're really untangling a deeply interwoven present, and we're restructuring a future relationship, especially when co-parenting with children is involved. So we are making complex decisions that impact homes, ongoing incomes and retirements, as well as the ongoing parenting issues. So the traditional high-pressure civil structure typically falls short of meeting these really unique human needs in a family law case. And what this means in a family law case is that we can really break the process down differently into a series of manageable, focused sessions over a period of time rather than that one and done kind of all day, all night session. So instead of relying on the pressure of this ticking clock, we're guiding clients through a step-by-step timeline with structure, but without rigidity. So this ongoing approach gives them the breathing room that they really need to process their emotions, consult with financial or emotional support professionals, and to be able to make thoughtful, long-lasting decisions about their futures rather than feeling pressured into a midnight settlement that they have to live with forever.
That's so true. I used to work for a provider that did a lot of consumer tort mediation, auto accidents, medical malpractice. And you're right. The day of the mediation was almost seen as the end of the case, if you will. There was an expectation that the parties would show up at 9 o'clock in the morning and leave at 5 o'clock in the evening, and they'd have a signed settlement agreement. Not that this would be a ongoing multi-step process for many months or many years to come. If you've suffered a slip and fall injury in a grocery store, it's not about preserving your relationship between the grocery store and the person that slipped in the store, right?
Right. Exactly.
So you discuss in your book the heart of a family law mediation case. Who composes the heart of the family law case? Are the parties in the legal action the only ones with the central role, or do outside family members, friends, clergy also play a central role composing that heart of the case?
Well, Aaron, in family mediations, I consider the heart of the case to actually be the two individuals who are divorcing. They are the ultimate decision makers. Of course, the family that they're making decisions for often includes children or even pets who are really central to how they move forward in their separation. Those children and pets are certainly at the forefront of of the negotiations, but they aren't making the choices. So in addition to that, we also have outside voices, as you said, friends, extended family, therapists, and clergy. And they can heavily influence the parties in this process. And that is one of the reasons why strong case management is so important. As a mediator, I think of my job as helping the clients to manage all of that outside noise and keep the momentum focused squarely on the two core individuals at the heart of their case. We're empowering them to make their own decisions. Of course, everyone's got, like I said, children and pets might be central to every discussion, but I think of it as the decision makers. Every time I come in, I think, I have no idea what's going to happen today. I don't know what they're going to decide. We have no idea what they're going to need, but they are the decision makers. And I think of them as being the heart, and we have to take their lead because we're leading the process, but really allowing their needs to be central to what we're doing. And I was also thinking that for the civil mediators, maybe listening to this podcast, this is the way that we are managing the outside noise is probably no different than they're thinking of when they have to manage the outside noise of corporate boards or shareholders or the insurance adjusters, right? The skill set of keeping the momentum really focused on the ultimate decision makers is exactly the same.
Now, you named a couple of the folks that are part of the process. Who are the professionals involved in the case? And as a mediator, how do you get them to recognize you not just as the mediator, but also as the case manager trying to keep everybody on the same page?
Yeah. In complex family law cases, the professional team it can vary so different. It's so different from one case to the next. One may have no outside professionals. One may have 6 outside professionals, right? And they're always a different mix. We frequently coordinate with consulting family lawyers who advise each client individually. We've got financial experts of varying degrees, forensic accountants or certified divorce financialists or other experts. We've got therapists, divorce coach, corporate, estate, and tax advisors. So it's just from case to case, we just don't know what it's going to look like, whether there will be any, and if there are, what they're going to be, what their role is going to be. So when it comes to getting these kind of really diverse groups of outside professionals to recognize me, not just as the settlement facilitator for the parties, but also as the case manager, I think of the expression, actions speak louder than words. If a mediator simply announces that they are the case manager, it doesn't really carry much weight, right? But if the mediator acts like the neutral case manager, the clients and the other professionals really do see and experience that leadership in action. For example, like when I provide a clear, comprehensive mediation summary to the consulting attorneys who were not in the mediation session, they don't have to guess at what happened in our session. They see the value in what I've provided, and the clients also get to minimize the amount of time where they're trying to catch their attorneys up. So in the neutral way that we're drafting the mediation summary or other mediation follow-up is always, it's agenda oriented, it's very organized, it's keeping everybody on track. The other ways of, sort of showing that this is what you're doing rather than telling them is I start every meeting by getting alignment on the agenda. And I end every meeting by clearly identifying every action item and the timelines. This is for the financial experts, for the attorneys. It might even be for the mediator or for the clients. Everybody's got something that needs to happen, and somebody is tracking all of that in a neutral way and very clear way so nobody doesn't know what's happening. But what I'm doing is I'm just practicing. I'm actually doing neutral case management, even if nobody has appointed me or, really giving me that title. It's not a title, it's just what you're doing. So by really consistently choreographing those moving parts, keeping all the various professionals and everybody involved organized, the outside professionals naturally begin to see the mediator as the central hub of the case that is keeping everything moving forward.
One of the things we're working on at the American Arbitration Association is EDR, early dispute resolution. And one of the parts of that is using early neutral evaluators in other different types of cases. Essentially, for those folks in our listening audience that don't know what an early neutral evaluator is, it's usually an expert in an area of law that's brought in early in the process to kind of evaluate the case and tell the parties, okay, this is what would happen if this went to trial. This is what the cash value of a case might be. And that's pretty easy to do in a situation where, let's say, someone's been in an auto accident. They have a herniated disc in their lower back. We know what the medical costs and the future treatment costs are going to be of that, et cetera, et cetera. So if that individual early neutral evaluator says, okay, well, this is what the case is worth, you should take it, oftentimes that works to settle the case. But can you explain kind of why that doesn't work in the family law context?
Yeah, you are exactly right, Aaron. In a standard civil case, like, say, a breach of contract, an early neutral evaluation works well because the dispute, it's usually just about finding a monetary number to sever ties, right? But like we said before, family law requires a much more, what I think of it is more holistic, nuanced, and even curious approach. We aren't just, dividing a spreadsheet. We are restructuring a family's entire future. So in a family law case, if a neutral evaluator steps in early and kind of dictates what a successful outcome should look like, say, telling them who gets the house or what their parenting schedule will be, they are completely stripping the clients of their agency that is so important in family law cases. It would ignore the emotional nuances and the unique, really subjective needs of each specific family. In addition, really, in the psychological research and our own practical experience tells us that people are far more likely to comply with a long-term, ongoing agreement, which is what family law agreements often are, that they helped to build rather than one that was dictated to them by a third party. And so this is why in family law, the neutral shouldn't dictate the outcome. Instead, we use this neutral case management structure to structure the process, giving the clients the safe, organized framework they need so that they can make those really deeply personal decisions for themselves. I think about the fact that you can have two cases where the fact pattern, there might be similar assets or similar, family dynamics or makeup, but the outcome, the settlement results for both of those cases could be vastly different, right? I can't come into a case predicting what it's going to be, even though I know what all the legal issues are. I know how a court might determine an outcome on certain issues when there's black and white issues. A lot of family law is actually gray, kind of in the legal structure, but we can't predict it because it's so deeply personal.
I was going to ask you, mentioning coming up with a long-term framework for a divorce settlement or if there's child custody issues. How often are you brought in after negotiating, let's say, an initial settlement, a couple years later if there needs to be a modification?
Sure. Yeah, we call those, post-judgment mediations, post-judgment issues that arise. It could be support modification updates. It could be somebody had a long-term agreement on a family home co-ownership. Could be various things. There are certain issues in an agreement that can be set in stone and others that have modifiability provisions. We're often requested to come in to mediate issues, sometimes that were predicted and sometimes that weren't, but they're more limited mediations, and sometimes people don't actually even need a written agreement after those post-judgment mediations, because it's more that they haven't talked in a long time and they needed to get on the same page with something. So that's fine. That's one avenue. But we often end up with amendments or addendums to the marital settlement agreement, just depending on what the issues are. If it's just parenting related, we probably would send them just to a co-parent counselor to work those issues out. But financial things that need a settlement update, we would certainly be involved in.
Getting back to the book, let's see here. What are some of the litigation inefficiencies common in other areas of civil law that your process can address?
Well, in litigated cases, across all areas of civil law, whether it's business dispute, a personal injury claim, or employment issue, for example. I think we all see progress often bottlenecks because of overburdened courts, as well as what is really an inherently adversarial structure of the court process itself. The separate attorneys work as opponents, and their ability to work well together really dictates how fast the case moves towards a resolution. And that's really, we see staggering inefficiencies in those cases. Common examples maybe, discovery roadblocks, like refusing to participate in informal discovery that could move things forward, or propounding antagonistic requests that if somebody was overseeing it more intimately than the court, that wouldn't be happening, right? Sometimes it's just containing the process a little bit more that might be needed. Or another example of inefficiency, just really the lack of cohesion, which is the thing that frustrated me about litigation, both in civil and family law, because the attorneys are lawyering in parallel, right? As adversaries, certainly not as a team. There's no cohesive plan to keep things moving between what ends up being infrequent court appearances. So the professionals may be used to and not mind this kind of pace, but individual clients, they really are often frustrated by what I see as the glacier pace of those cases in many areas of law. So the neutral case management that we're talking about here today really addresses all those inefficiencies, with the mediator acting as a central hub outside the limitations of the court's calendar. Sort of a little bit like a private discovery referee, but for all stages of the case. So this framework it applies to family law, but also to any civil mediation, because this case manager can step into that captain role to lead the process, track the timeline, and just really manage the flow of information between lawyers and experts. So there is someone steering the ship. And the last point I was thinking about this with neutral case management, instead of the two adversaries fighting over every step in really a combat zone, the case managing mediator creates an agreed upon structure, tracks agreements, ensures action items are actually complete, not just with discovery, but in all of these areas. And it really does transform a chaotic process into a much more organized workflow, which keeps the case from languishing. And of course, the sooner you can get to resolution, the sooner you have happy clients.
You mentioned just the discovery process there. I mean, one criticism of arbitration is discovery has gotten kind of out of control, where you have one party asking for things that are completely unnecessary,
Right.
the other party refusing to provide anything, or the information that they provide is not actually what was asked for. I can only imagine in the family law context, unless there's somebody steering that part of the ship, that can become one of the most costly and frustrating parts of the process.
Oh, it absolutely can. And even, even in mediations where it's not so high conflict and people are working collaboratively together, sometimes there are issues that come up and one client or their attorney says, well, we're going to need all these documents, and has this huge list. And I'm looking at it and thinking, well, okay, what's the purpose of this? What would we do once we get this information? And we have them articulate it, but we're talking through it, right? We're not grilling them. This is just, we want this to be efficient. Everyone's agreed that this is what we want. And now let's manage this a little bit more. Do we really need 10 years of credit card statements, right? What are we doing with it once we get it, right? So I absolutely agree. It's great to have somebody who can manage that and balance that a little bit more, and not have it get so out of control like it seems to be in the arbitration world.
As a team leader, why is it important for the mediator to have a curious mindset, and maybe define for the group what a curious mindset is?
Well, I think a curious mindset is critical for all mediators, especially when you're leading the team, because if we are only focused on settlement at all costs, we end up bringing a hammer to a situation that maybe requires a more delicate or a more holistic touch. So to manage a case effectively, if we say we need to be curious, what do we mean? We have to ask questions about our clients and about the circumstances. Whether we're asking them out loud or in our heads and figuring out what the answers are, it is that curiosity that is so helpful. Like questions such as, what led these clients to this point? Or who are these clients as individuals, or how they present in the world or in the relationship with each other? And what is really happening behind their outward presentations or their positions? Like, if we don't ask those questions, whether outwardly or inwardly, we're really missing the opportunity, I think, to reshape the dispute or find truly creative solutions. We always talk about mediation being there are creative solutions, this is what we're doing. But if you have a formulaic approach, how do you bring creativity into that? You can only do that by figuring out what your particular clients need, who they are, and because you don't want to present options to somebody who you know it's going to be a bad fit for, right? So the more you get to know them about their circumstances and you can think about ideas that might help them, if you present ideas that you know are so off base for them, they're going to look at you like you don't get us at all, and they lose trust in you. So we have to bring curiosity, and we cannot bring a formulaic, rigid process to this intensely human conflict and expect some a transformative outcome, which is a great goal. Ultimately, I will say, I think curiosity is what makes mediation work so fulfilling for me. It allows me to look past standard legal formulas or frameworks, get to know who my clients actually are. They feel that is happening. They know that I am trying to get to know who they are, and they can tell in the conversation by the options and the ideas that we're discussing that I am addressing them as individuals and what their needs are. And really, that curiosity is what helps us build a custom agreement, as well as kind of that overall roadmap for what these clients need in the process. And I certainly think that applies outside of family law as well.
Which types of clients have the best results when working with a mediator who is also in a case manager role? In which cases would this style not work so well for? And then along those lines, how do you evaluate which cases to take during your intake process? Because obviously you want clients that are going to want to work with your structure, right? So explain that.
Yeah, exactly. Yeah, so this process, the case managed mediation, it is highly effective in most cases, but certainly not all cases can be managed, even by an experienced case managing mediator. Higher conflict cases or cases with severe psychological complexities might ultimately require a decision maker rather than a facilitator. So during my intake process, which is so important and has certainly evolved over the years, I work to evaluate both clients' personalities, how they communicate with each other, how they communicate with me or any other professionals who might be in the introductory mediation. I'm really looking at the extent to which the potential clients are open to accepting guidance from a neutral professional. Again, guidance on the process, not guiding them and telling them what they need to agree to, right? They're the decision makers. But if a party or client insists on controlling the procedural framework or actively refuses to let a neutral manage the workflow, then mediation, in my mind, then really becomes, it's just like court, but in an office, right? It really becomes a venue for what we'd call parallel lawyering rather than really collaborative resolution. On the other hand, when clients or families present with other needs, we consider whether a co-mediation structure might be beneficial, often with an experienced psychologist or a co-parent counselor in addition to the attorney mediator. Again, the mediator needs to be asking questions to figure out what the clients in front of us right now might need, and that might not look anything like the clients we met with earlier in the day.
So sometimes you might bring in a co-mediator to work on an underlying issue to be worked out before it gets to you for the overall issue.
More so than that. So sometimes I do that. Sometimes when people come and they want to have a mediation and I say, okay, they're not ready yet. They need to have something else happen first. But more commonly, this idea of a co-mediation structure is that there are two mediators, maybe with some overlapping, but also distinct areas of expertise where we're going to guide them through the process because they have so many overlapping, intertwined issues, right? Where there's a family home, there's children, maybe they've got high needs, support is intricately intertwined with that as well. There are levels of complexity with everything, and they're all kind of tied together. and you see that the family needs a little bit more support, then the structure of two mediators working together throughout the process in each meeting, essentially, it's a much more contained and supported process. And it's not for everybody, but it is certainly a great strategy for a lot of families.
Can you talk about the mediator's role working with the court?
Sure. This varies from jurisdiction to jurisdiction, but for me, as a case managing attorney mediator, I do actively file pleadings and interact with the court on behalf of my clients. This includes drafting case initiation pleadings, tracking and continuing status conferences, and ultimately submitting the final judgment documents. So I'm acting as the central nexus, so really the clients don't have to navigate the court system on their own or even at all, because we're doing that. And we're monitoring the court's processing to ensure really smooth path to finalization. Of course, a mediator's ability to interact directly with a court varies so much, not just on the jurisdiction, but also based on professional backgrounds, right? There might be therapist mediators or financial mediators, and they can work the entire case, but they are not permitted to file directly as an attorney mediator, at least here in California, is permitted to. So in California, while the rules do allow attorney mediators to draft and file pleadings, some courts, even in California, make that much easier than others. Some courts have a process for this, and others just make it so clunky, and you have to file 10 different documents just to be able to file any pleadings on behalf of your client. So it's a work in progress, I'd say. But in other states, or especially for mediators who are not licensed attorneys, local rules might certainly prohibit the mediator from drafting any legal documents at all or filing anything on their behalf, because that's considered the unauthorized practice of law or crossing, ethical lines. But this is actually a great example of where this concept of neutral case management really shines, I think, because even if your local or state rules dictate that you cannot submit or sign pleadings, you can still act as the team captain. You can track court deadlines. You can monitor the public docket, the court dockets. You can coordinate with the clients or their consulting attorneys to ensure that the right documents are getting filed on time. So the goal of neutral case management isn't necessarily about doing the filings yourself. It is about providing the organizational oversight so that no deadlines are missed and the family isn't left to figure out the court system in the dark. And it can get really complicated when there are consulting attorneys, or when one person has a representing attorney and the other has maybe a consulting attorney or has decided not to have an attorney at all. Nobody knows who's doing what, right? There's an upcoming status conference, and the deadline to continue that is 10 days before the conference. And nobody knows. Somebody assumes somebody else is going to do that. We don't make any assumptions. We say, here's an upcoming deadline. Who's handling it? Do you want us to file a request to continue, or who's going to do this? It's always here's the action item. Who's got to do it? We don't mind. It's not that we are trying to keep all the time and billing for ourselves. It is that we need to identify what all these issues are, who's going to do it so it doesn't get missed or, fall through the cracks.
Now along those lines, you mentioned preparing documents for the court. Obviously, financial disclosures are very important in a divorce case. What are the advantages of having the mediator prepare these as opposed to just leaving the task to the parties?
Well, first and foremost, I think that having the mediator prepare the financial disclosures prevents inconsistencies between the two parties' lists of assets and balances, right? Account balances or asset values. And so that immediately levels the information playing field. The number of times that we have mediations where both parties come in with their own separately prepared financial disclosures, or their attorneys have prepared them, the amount of time that it takes us to actually unravel this, to figure out what assets they're talking about because somebody didn't include an account number, or one person referred to it in one way and the other person referred to something else, or there's a $200,000 account value difference between the two parties' disclosure sets. What are we relying on? Right? So having a single consistent documentation of this, we of course gather the supporting documents as well, right? So we want a source document before we're going to identify the account detail and the account number. We don't just need that for the financial disclosures. We need that for the settlement discussions. It often happens that we come into a mediation and somebody says, well, I don't have any retirement accounts. I say, oh, well, I see an IRA here. Was that a retirement account? Right? Or
Right.
I mean, it's terminology. Sometimes it's familiarity. People don't necessarily know, or they speak different languages. One's a, tech stock expert, and the other person is, in healthcare and has no understanding of how, corporate employee equity grants investing might work. So it is leveling the information playing field, having consistent information, but also ensuring that we have the right information coming into the mediation. So ultimately doing this centrally with a mediator, it streamlines professional time. It prevents the need for expensive duplicate efforts by the separate attorneys that then still need to be reconciled in mediation.
I don't know if you were an accountant in a former life before you were an attorney, but you certainly learn a lot about accounting in the family law context as you go along.
Absolutely. That's right. Absolutely.
All right. How can making a plan for the start and end of the case, even before the case is filed, move things along, and how can the mediator manage that process?
Well, in family law cases, making that plan together at the outset really, it helps minimize surprises and inconveniences. So, for example, in the start of a divorce case, there's a divorce petition that gets filed and then served. Of course, now, thankfully, we've got joint petitions where they don't need to be served. But still, there are a lot of situations where there is the separate divorce petition and the response that needs to happen. People get surprised by service all the time. They get served at work. They get served at a family gathering. It's really erodes trust and goodwill, and that impacts the tone and the ultimate outcome of the case. It sometimes even impacts whether mediation is possible. So creating a plan up front, we minimize surprises. Well, I always like to say nothing happens in mediation without both people agreeing to it. So that means there's no unilateral actions. Nobody's running out and doing something. So we are talking about issues like, when are we filing? Who's going to receive what? What about health insurance? Are we keeping health insurance? And until when? What are the next steps on that? Issues, when I think about the end of the case, I think, when are we going to finalize a divorce? Is it going to be this tax year or next tax year, or even beyond that, because those are all options? But we want to figure out all of those questions: health insurance, tax filing, beneficiary designations on accounts, and life. All those things, when we talk about those up front, we make sure there are no unilateral actions taken before the divorce is finalized. Everybody agrees on a plan. We're the creators of the plan together. It helps them to, again, that agency I talked about before, it really empowers them to know something's not going to happen to them. It's often difficult because while some parties come in having agreed or made the decision jointly to divorce, other times that was a unilateral decision. So if you can take that and say, okay, we understand that was difficult, that is not it's not their preferred course of action, but now they've both agreed to mediation. Now let's agree on a plan together, so that, right, they're in this together, and it's no more of just that reactivity and feeling like everything got pulled out from under you.
Yeah. I can only imagine you've heard some crazy stories, like somebody being served divorce papers attending somebody else's wedding or something like that, right? Can you imagine how embarrassing that would be in front of everybody, right?
Absolutely. And in fact, one of the things that's always frustrated me a little bit is coming into mediation, as I talked about before, I do an introductory mediation first to make sure it's a good fit for everybody. And then we all sign the agreement to mediate, and then we move forward into the first full mediation session. So in that first full mediation session where everyone's agreed we're going to mediate, everyone signed the agreement to mediate, the day before, or like literally it was the night before, this most recent one was the night before this first full mediation, somebody had a process server deliver the divorce petition to one of the people. So of course this person comes in completely rattled. Like I always say, we want their prefrontal cortexes and everything to be calm. We don't want people to be in fight, flight, or freeze when they come into this. So that is exactly what they did, but they did that because their attorney advised them to. So that I try to encourage the attorneys, let them know that I've got this process. We're going to work out the details. The clients are going to decide who's going to be the petitioner, right? Who's going to be the respondent, or in the joint petition has different rules now, but still it's letting the attorneys know that on the process, we're going to manage the process. We will interact with you and coordinate efforts. You're going to be in the loop. It's not that we're trying to exclude you, but my God, please think about the actions that you're advising taking when these people are just getting into a process and trying to rebuild a little bit of trust and goodwill so that they can work together and collaborate on decisions.
Part of your process is using mediation summaries. Can you talk about what you like to include in those mediation summaries and how they keep everybody on track?
Yeah, this is honestly, Aaron, it's really one of my favorite parts about case management because it really directly addresses the biggest complaint people have about the legal system, which is feeling lost. So I often tell my clients that my mediation summary is like that red "you are here" dot on the map that I mentioned earlier. If you don't know exactly where you're standing right now, it is terrifying trying to figure out how you're going to get to the final destination. And so my goal is to really make sure no one ever feels lost in the process. So for our working sessions, the mediation summary acts as a comprehensive living roadmap. I send out a document that captures, from a strictly neutral perspective, everything that we know about the case with an eye on what will ultimately be needed for the final settlement agreement. I include the family's statistical details, their date of marriage, date of separation, legal, all the details about children and where they're living and everything like that. The exact status of their court case, what's upcoming in their case, what needs to happen, any written agreements they've signed, what their big picture goals are, and a running list of all the substantive, tentative agreements they've reached so far, as well as what all the open substantive issues are and what needs to happen. So it's always at next steps. Here's what your homework is, right? I talked about that before, but everything's contained in this really comprehensive mediation summary. But of course, not every single interaction requires a full formal mediation summary like that. So between more major sessions, we often have quick check-in meetings or, I call them case management meetings. But in those instances, just keeping everyone on track means sending the short bullet point email outlining what was discussed and the immediate next steps, right? It's all about matching the level of documentation to the situation. So we're maintaining momentum without overcomplicating things or running up unnecessary professional fees. So whether it's a full mediation summary or just a quick bullet point email, the way that we keep everyone on track is through the action items and next steps. Like I said, we are literally spelling out who's doing what before the next meeting. Like who's calling the real estate appraisal, who is downloading retirement statements. And by putting this in writing, there's no confusion and no dropped balls, right? The other thing that I always think is I want to get the mediation summary or those bullet point emails out as soon as possible after the meeting. One of the reasons is it's fresh in everyone's head, right? So it'll be easier and quicker even for the mediator to get it out. But also, if the mediator doesn't send a neutral follow-up, you know what ends up happening? You end up getting a non-neutral follow-up by somebody else. Here's what I did, right? And they give all their things, or here's my take on what we discussed. And then they out, nothing about it is neutral. It's completely partisan. It may even be, maybe not aggressive, but it may have a tone that we would not want to have in the discussion. So it is important for the neutral mediator to get that follow-up, ideally just after the mediation or the case management meeting, so that everybody knows what needs to happen, everybody knows what their timing is, and they can work on their own calendar side what they need to do. But it also helps because then you come into the next meeting and everyone's got the exact same list of what we agreed was going to happen next and when. So I see this not only as a benefit to the clients, also to the separate attorneys, and also for the mediator, because I hate coming into a meeting not knowing where we left things off. That is one of the things that drives my summaries is when I come into this, whether it's in a week or what if the next meeting is in 4 months? Like what if something happens and it gets delayed and we're meeting later? I'm not going to remember all the details that we talked about. So I'm trying to give everybody the same roadmap. It helps, it saves people time, and I think it saves in professional fees, because once I've mapped that out, everybody doesn't have to go through their own notes to figure out what their to-dos are or what they're supposed to be doing in advance of the next meeting. So, and ideally, I think the whole point of all of it is it keeps everyone's anxiety levels down. Everybody knows what's happening. We're all on the same page. We're just moving forward.
All right. Fast forward to the settlement agreement. In most mediation, mediators do not have a role in drafting settlement agreements. I'll go a step further than that. I mean, I've seen mediators been asked to step in and help with the drafting. I've heard of parties out of mediation, attorneys adding a line for the mediator's signature as a witness to a settlement, all sorts of stuff, right? But traditionally, what makes family law different when it comes to the mediator actually having a role in the drafting process?
Yeah, I know in traditional civil mediation, I think we often see the mediator drafting maybe a term sheet, if anything. But really, the parties' separate attorneys take over to draft the formal, legally binding agreement. In family law, I always recommend that the neutral mediator, attorney or not, prepare the first draft to the extent possible. As an attorney mediator, of course, my first draft is going to be a draft marital settlement agreement. If it's a psychologist or a financial mediator, they're more likely going to be drafting something like an MOE. But as the neutral, we have a different perspective. We are focused on balancing both parties' rights and needs in the process, not just their legal rights, but also emotional rights, like their emotional needs, I should say. Sometimes an attorney might be drafting something and they say, okay, well, this is fine. This is what we agreed to. And they don't see that the other person might be offended or upset by something in the drafting language. And that's understandable because their focus is not on balancing the needs of both parties. Only the mediator knows both clients as much as the separate attorneys know one client. And so I always take that and say, draft to the extent possible based on your legal or non-legal background so that there's no question, because who's going to fill in the details? Separate clients are going to fill in details if you leave them out, or their separate attorneys are going to fill in the details. So to the extent that you can, drafting this for them to review from a neutral perspective is going to help the family the most, I think. That's been my experience. Family law is also a little bit different than civil in that there are often cases where there are no separate attorneys involved. It is just the mediator. Of course, we've got, our waiver of mediation confidentiality in a written agreement because this was a product of mediation, but so we need to have them waive on a limited basis the mediation confidentiality when they're signing an agreement that's drafted by the mediator. And also the mediator does not sign. Mediators don't typically sign the marital settlement agreements, but if there are separate attorneys, they're reviewing and signing. If they're representing, if they're consulting attorneys, they don't always sign, but they might be mentioned. So it is a little bit different. I know sometimes in civil attorneys and mediators realize what family law mediators do. It is a lot different. Right? How often do civil mediators file documents on behalf of clients? Right? It doesn't typically happen, but in family law, it is. I think that the family law mediation has always been supported by the courts, and I think, in fact, was initially promoted by the courts, at least in California, back in the 70s. So I think that there is a lot of support for that, and I think that's the reason that they encourage, or that they certainly don't discourage, having the mediators bring in more efficiency and more balance into the process, because these can easily dissolve into really, really complex litigated cases that really don't have an end. So I think the courts support that.
Now, looking past the settlement agreement, why is it important for the mediator to stay with the case past the settlement agreement and through the final judgment?
Well, okay, so there's two phases to this. One is getting the final judgment through the court, and the other is fulfilling the actual terms of the settlement. Right. So in family law in particular, our job is not just to get signatures on an agreement. It is to ensure our clients actually reach the destination that we all charted together. Our clients absolutely still need a project manager at this stage, someone needs to coordinate the signing of the formal judgment documents. Somebody needs to ensure the submission to the court happens, and also to distribute the final approved judgment to the team. So regardless of whether the mediator or the attorneys actually submit those filings, the case managing mediator, regardless of their background, can track its progress, check the court files so the clients don't have to, and provide updates to the entire team. So if this is left to a separate attorney, what's the separate attorney's job? Separate attorney's job is to let their client know what's happening. Wait, we saw this update in the court file. We're still waiting for it to receive the hard copy or the electronic copy, but we see that judgment was entered. Do they really have an obligation to send it to the rest of the team? So what often happens is I see one attorney, when there's not a neutral case manager, I've seen a separate attorney let another separate attorney know what's happening. That doesn't filter down to the clients, or it filters only to one client. So as the case managing mediator, our role, our job really is to make sure everybody has the same information provided in a neutral manner, to do as clear as possible, let them know what's happening next. Right. So we might get, if it's a separate attorney, they'll say, here's the judgment. You've just got the judgment. I said before, there are some courts in California that if there are representing attorneys, the mediator cannot file on behalf of the clients as they could have if there were not representing attorneys. That's not most courts, but there are a few courts that are still like that. So in those cases, when there was a separate attorney involved and they're having to monitor the judgment, they might just send the judgment. Here, we got the approved judgment. Nothing else. Nothing about when the judgment is entered, when the official divorce date might be, which is different. There could be different dates. Nothing about what transactions need to happen next. Nothing about what's the status of the retirement transfer by the QDRO, the Qualified Domestic Relations Order that's required to do retirement transfers. So as the case managing mediator, you're neutral and you're saying, okay, we see that this has happened. Now here's what still needs to happen. You've got these jobs, you've got this, or we're waiting for this to happen on the QDRO piece. So that way nobody has to wonder, because I always wonder when I see those emails, right? I get that email, here's the judgment. I think, so is there something, is the case done? Clients don't know that. If I don't know it, they certainly don't know it. So it's just providing that clarity all along the way. So that was the first part of your, the answer to the first part of your question. But so the other part is the beyond the signing and beyond the final judgment from the court. This second phase I think of as guiding the clients through fulfilling the immediate steps required by their agreement. So not all clients need this level of support, of course, but we can offer our neutral guidance so they don't feel lost trying to figure the real life pieces out on their own. This might include making sure settlement payments actually get made, or letting them know the timing, right? Because sometimes the settlement payment needs to be made within X days of them signing the agreement, or it might be within a certain number of days after the court approves their divorce judgment. So whatever the triggering event is, we want to say, great, now that this, whatever step, this has happened, the settlement payment is now due within this, by this date. So that is the most important thing, I think, because a lot of mediators just, sign an agreement, your judgment's done, good luck, have fun figuring out all the other pieces. But so there's this settlement payment, making sure that gets made. There could be property title transfers, or those retirement orders I talked about. It could be vehicle transfers, or there could be stock transfers. What does Morgan Stanley require versus Charles Schwab? And, what internal documentation do they need? Does somebody need a notarized document? We should know all those things before they sign the agreement, because we know what transfers are going to be needed. So we're coordinating all of that. But still, they don't know. They're not experts at this. These are their assets, but they still have no idea, because most of them haven't divorced multiple times and had to transfer all these assets. So that's what our job is. We are the experts. So I always say, as the mediators, we don't necessarily have to be directly responsible for transferring those things. But as the case managers, we identify who's responsible and follow the project through to completion, just so there's no loose ends. The number of loose ends in family law cases, it's staggering. And it was something that really frustrated me when I was in litigation. So as a mediator, especially as a case managing mediator, there are no loose ends.
All right. That kind of concludes our session here, but really quickly, is there anything else you'd like to share? And how can listeners reach out to you with questions or comments? Should they visit your website, email? What's the best way?
Yeah. Well, anything else I'd like to share? Yes, I would say I am an eternally optimistic mediator. I think that's why I got into this in the first place. I really truly believe we owe it to our clients to provide the best possible process for them. This is such a difficult time for them. And my hope with the book is to inspire other family law professionals to see neutral case management as a powerful tool to bring transparency, efficiency, and collaboration to their own cases. I would love to see more attorneys transition into mediation and to see more separate consulting attorneys really recognize the value that case managing mediators can bring to the entire professional team. From a purely practical standpoint, when attorneys prioritize the client's experience and keep complex cases moving forward, the natural byproduct is a thriving practice. Because clients who feel supported rather than financially drained become your best advocates. And in my experience, also grateful colleagues become your strongest referral sources. I've had many attorneys who have never experienced a case managing mediator and have said afterward, I cannot believe what a difference this makes in our cases. And they refer more cases to us because of that. So it helps everybody. It's not just a mediator. This is helping clients, everybody involved in the process. So I hope that this is a helpful introduction to case managing mediation. I am certainly open and available to connecting with other mediators and attorneys. Happy to if you want to find me and connect with me on LinkedIn or at my website, lahanlaw.com. And of course, we know that your listeners, Aaron, can find the book on the ABA website, right?
That's right. Well, thank you very much, Paula. I've appreciated our conversation today. Everybody go out and buy Paula's book.
Thank you so much, Aaron.
Thank you for joining us on Resolutions. Today's episode has illuminated the powerful impact of effective dispute resolution and showcased the incredible individuals who dedicate themselves to this important work. Our mission is to explore the diverse world of dispute resolution, and we hope we've inspired you to engage with conflict and collaboration in new ways. If you're not yet a member of the ABA section of dispute resolution, we invite you to join our community of professionals making a difference. Your involvement can help us build a more harmonious society together. And if you found value in our conversations, please consider leaving us a review and a 5-star rating wherever you listen to podcasts. Your feedback helps us reach more people and continue our journey towards excellence in dispute resolution. Until next time, keep solving problems, building bridges, and creating positive changes in your communities.